lien holder. They served that, the second mortgage, they served them at the wrong address. Well, that second mortgage holder or whoever has an interest in it, if they're not served properly, they can come back later and say, hey, I wasn't served properly. You still owe. I still have interest here. So common things that you may have to do with those kinds of things, and there could be other issues that come up in the normal scope of buying a property. I'll give you an example. As an agent, I sold a property once where 50 years ago, two sisters and a brother sold a property, but only the brother signed the deed. They weren't all that picky back then, and mistakes are made. So the question was, did the sisters intend to sell their interest in the property? And this is 50 years later. Because those sisters could pop up and say, hey, we still own part of that. So in my case, we were actually able to find the sisters. They were still living locally. They were in their 80s, going to the same church as the buyers went to. So we were able to get them to sign off on it. Yeah, we got our money. But when you can't, to clear up these, they call them clouds on the title. They're uncertainties, whether someone might be able to claim an interest. You end up paying a lawyer to do what's called a quiet title action. Quiet title, what's basically going to happen is you're going to file for a hearing with the court. Court's going to take and advertise the fact that you're having this hearing, and it's basically going to say, hey, show up to this hearing or forever hold your peace. We're advertising it multiple times, I guess, over a period of time. And if you really have an interest, you'd be reading those legal notices, I guess. Nobody does. And I'm sure very rarely does anybody actually show up. But you go through the process, the lawyer goes to the hearing for you, and the judge says nobody has any interest. It's done. You're cleared. If you had interest, they needed to show up. So that's what you end up having to do to handle these uncertainties on a title. But you're paying, so be ready. Be ready that you're going to have to pay a couple grand to a lawyer to handle that for you, because that's not realistically a DIY kind of a thing. I already mentioned like estate taxes. That's, like I said, a common thing, especially with the tax sale process. Very common for estates to end up there. Talked about holdover occupants. All right, so opportunities. So far, I would say the actual sheriff's auction sounds scary and difficult and not conducive to the average person showing up to buy. I think that's kind of a fair assessment because that's how I feel about it. So does that mean there's no opportunity? No, that doesn't mean. It's an opportunity for some people, but why do you have to wait until the sale to buy it? When I'm looking for opportunities, I'm looking for distressed conditions.
Like grass.
Grass, stuff like that. Well, kind of. So when I say a distressed condition, it could be physical condition.
Okay.
It could be the financial situation of the owner. It could be legal situations. It could be some combination. If they're having a distressed situation and it's something that I can take on or do something with, that's an opportunity. Because now I'm able to do something nobody else can do. If you are a contractor, maybe you specialize in foundations. Well, if you go find a property that has a foundation that's right. Caving in, and I know of one, and I actually know the owner, I just don't do foundations, and it just doesn't seem like it's in my wheelhouse. But if I was a foundation guy, well, that's the perfect opportunity for me to get that deal because everybody else can be scared of it. Nobody else is going to know how to deal with it, or very few are. That's an opportunity because I can do something other people can't.
True.
So if you have money sitting around and somebody's getting foreclosed on, well, you could go and buy it beforehand. Or in today's market, what if you looked at the tax auction and you're looking at August and you see a property that's of interest and you look into it and you say, oh, they bought it only 4 years ago. Yeah. Well, what was happening 4 years ago? And you can see that the moving party is probably the first mortgage, so they just have a regular mortgage on it. Well, 4 years ago, what were interest rates like? Oh, it's their primary residence interest rate. They might have like a 3.5% interest rate. Well, that's pretty good, So even if you bought it at the same price as what they owe, if you either did a mortgage assumption, like maybe you just wanted to take it on in your own name, you could get that 3.5%. Or you could take and offer to do, I don't know if any of you ever heard of a subject to. So I've never done one. I understand what they are in general, and I think it's an opportunity. A subject to deal is where you have the owner give you a deed. So they give the property to you, and they give you like a limited power of attorney to deal with the mortgage. So now, even though you may not be able to assume the mortgage because maybe you want to buy the property in your LLC, and the LLC is not qualified to assume the mortgage. Well, so they give you a deed to the property to your LLC, and they give you legal authority to deal with the lender. So you show the lender your limited power of attorney. The lender will talk to you. You can make your payments. You can deal with the lender any which way, just as if you were the borrower, because you're now legally representing the borrower. So now you own the property. You didn't necessarily, and maybe you give them a small amount to get out from under.
Does the bank know about this? That what we're talking about right now?
Well,
or
in that case, they
under the table.
In that case, they would know, kind of. So two parts. So part of it they would know. There'd be part of it that they're going to probably going to ignore. So so yes, they would know that you're dealing with them because you're going to be giving them the power of attorney.
Sure.
Okay. Will they know that you have taken ownership of the property? Maybe, maybe not. They may be monitoring that. Technically, they can call the loan due whenever the property transfers. They call it the due on sale clause. I think it's exceedingly rare for it to happen because as long as they're getting paid, nobody cares. When you're talking about a primary residence mortgage, those the lender you get the mortgage from. So if you go to Community Bank and you get a Fannie Freddie conventional mortgage, you're not really getting it from Community Bank. They're originating the loan, but they're going to take and resell it, and it ends up getting resold, and then it gets bundled up into an equity, and then it's invested in like a stock. So you get pension funds and whatever large institutions, they buy they're not buying like individual mortgages, they're buying into groups of mortgages, and all they care about is the performance. Well, just because a property sells, do they want to foreclose? Well, that gets them a worse return. Foreclosing is expensive, and the property becomes more distressed, and they're going to get a lesser return. As long as you're paying, they're unlikely to exercise that due on sale clause because that just costs them money. So I'm not saying it will never happen, but I think it's exceedingly rare.
No, I get
so
that.
They may know about it, they may not know about it, but even if they know about it, I think they're very unlikely to act on it.
If they were to become aware, is that something that they would have a problem with per se?
The only thing they could reasonably do is exercise the due on sale clause and
just say now you have to buy it.
Well, yeah. Basically, what happens is they make the entire amount of the mortgage due and payable. So at that point,
calling the loan.
Right. So yeah, they're calling the loan. So if the balance is $90,000, you gotta come up with the $90,000, or they're gonna foreclose. But you just go and refi it out. Right. You want to have the ability. The big opportunity is you're taking over that loan at 3.5%.
All right.
Yeah, that's great. So worst case scenario, you got to refi it out at the current rate.
But as long as you're paying it every month, they don't care. You know what I mean?
I can't say for certain, but I think it's highly likely that they won't care because why would they
they're
foreclose
still getting money.
Right, they're getting what they want.
Right.
If you stop paying, well, then it's just like any other non-payment.
Right.
And the subject to whatever agreement you had with the owner, not the owner, the bank's the owner, the person who lived there that you're buying the house from, that would just say as long as you made your payments, the house no longer belongs to them, something along those lines. How does that work?
Okay. So you made one mistake. Are you from a Western state? See, it's a little different in different states.
I was born in PA, lived in Florida, and just moved back here.
All right, so you're an Eastern person. So the bank doesn't own the property. You own the property. So the bank has a lien on it. If you're actually in a Western state, they call them title theory states. It's more like having a car loan where the lender holds the title. But here, the owner owns the title. So what happens in a subject to, the owner gives you a deed. So you own the property as soon as he gives you the deed. Okay, But what you also want is you want the ability to control the loan because you want to make sure that the lender doesn't foreclose. You want to pay the loan.
Right.
So that's the other part. That's the part where you have the owner give you that limited power of attorney to act on their behalf with regard to the loan. And once they have that, you give that to the lender. The lender will now talk to you as if you're representing them, kind of like you're their lawyer.
And the deed they gave you gives you control over the property.
You own it.
Correct?
You own it. Yep.
Okay, that was the part I was
Yep.
trying to
Yep.
understand.
You own it. It's not the
Property
bank. The
was
bank
fine.
doesn't control who owns the property.
Okay.
They have an interest in it and they have a lien on it and they have certain rights, but they don't own it. So you can transfer the property 10 different times over. The lender, as long as they're getting paid, is unlikely to want to do anything.
So this is happening during foreclosure? Is that when you're trying to assume
yes. So presumably,
Right
they're already
before, maybe?
behind. So if they're already behind, then the first thing you're going to do is you're going to say, well, what do I need to bring it up to date? Oh, I need to pay $6,000 to bring everything current. I'm going to pay the $6,000. Now we're current, and now I'm the property's nice. I'm going to rent it out. I'm going to make my money. It's a 3.5% loan. I got a rentable house the way it is. You could rent it back to the owner.
So this would only happen during how would you know that they were in distress? Like you would have to know these people personally. There's not.
The sheriff's sale list. That they're already, the August sales already has many advertised. So now you have a couple of months.
Yeah, so you could basically get that off a sheriff's sale because you're doing the subject.
Yep.
Would a good connection at a financial institution be the best thing you could possibly hope for? Because they're going to know about foreclosures before they've even begun to be.
Maybe, but
Right?
I don't know if they're going to give you insight on
Well, no.
people who are behind. If they are already foreclosing, if somebody's just behind, they might consider that more